Well, howdy there, folks. James, Political Friar, coming to you again. Got the Baylor law hat on, and so we're going to talk about a legal topic today. Specifically, we're going to talk about the rarest of equitable doctrines out there in the civil context in civil law, and that is offensive collateral estoppel. So much fun. Why is this important? Well, this doctrine is applicable to the E Jean Carrol case that kicked off its trial this morning with jury selection. And that jury is not going to be asked whether Donald Trump sexually assaulted E Jean Carroll in a department store. That fact is going to already be established. The jury isn't even going to be asked. The judges entered a ruling showing that Donald Trump did indeed sexually assault E Jean Carroll, and the jury is just going to be asked how much money E Jean Carroll is entitled to from Donald Trump. And you're going to say, wait a minute, don't you have to prove that he actually did it? And the quick answer is no, you don't. You don't have to prove that Donald Trump defamed E Jean Carroll because that was already proved in a previous case. Isn't that odd? Well, it derives out of a sense of fundamental fairness, and it actually derives out of a doctrine that you have heard of, and that's called double jeopardy. Now, many of you will know that double jeopardy means that when the cops arrest a person and the prosecutor tries them and the person is acquitted, that is, the jury finds them not guilty, the prosecutor can't prosecute them again. Can't no two bites at the apple. Even if there's new evidence, even if like the guy writes a book saying, if I did it, this is how I did it, the prosecutor can't arrest O.J. Simpson and try him for killing Nicole Simpson again. That's double jeopardy. Well, collateral estoppel is a flavor of the same idea, which is to say, once something has been established in a fair proceeding, you can use those facts as established. And so if a person is acquitted, even if there are new facts that come to light, you hold the previous judgment and you can use it again. Should the LA cops arrest O.J. Simpson, he would just get off. He wouldn't be on the hook for those murders, even if they knew he did it, even if there was new evidence. So collateral estoppel works in this case because Donald Trump already lost his trial against E. Jean Carroll. See, Carroll brought two claims of defamation. She brought a claim of defamation for what Donald Trump said in 2019 and a claim for defamation for what Donald Trump said in 2022. He said roughly the same thing. He repeated himself. But you do get to have a jury determine how much each individual instance of defamation is worth. What you don't have to do, at least if all the stars line up, is prove that he defamed you with the same words twice. He said she's not my type in 2019 and 2022, and when the jury in the looking into the 2019 case said, yeah, no, he definitely did sexually assault her and he definitely did defame her in the 2022 case because of collateral estoppel, your jury's only going to get asked how much money this one was worth. So this is particularly interesting because offensive collateral estoppel, what E. Jean Carroll is using, wasn't even recognized as a fair doctrine until 1979. Before that, collateral estoppel worked exactly the same way as double jeopardy. I mean, it's in the civil context, but it was only a defense. Only the defense could raise collateral estoppel. And that is something that changed when smart plaintiffs started deciding that, hey, we already litigated this, we don't have to do it again, and started making motions to the court. And the court has to say, well, I don't know. I guess, yeah, as long as the circumstances are right, we can do it. But it's a little bit more constrained than defensive collateral estoppel because there has to be this concept of mutuality. So what is mutuality? Well, it means that the proceedings were substantially similar. And you get this lovely, lovely quote from the Supreme Court saying, non-mutual, that is, when the proceedings weren't the same, collateral estoppel is inappropriate when it is, quote, unfair to a defendant. Define unfair for me. I love the Supreme Court when they're so clear about what is and what isn't unfair. So mutuality, here's an example. So that can help. In an administrative hearing, like in front of executive agency like the DMV or they can take your driver's license away, right? Because they can establish the fact that you were driving drunk. The DMV's decision that you were driving drunk cannot be used against you in your DUI trial. That is an agency decision, not a court decision. And so the circumstances are non mutual. That means no offensive collateral estoppel for the government in that case. Here, with E Jean Carrol, it couldn't be more mutual. These proceedings were in the same court system under the same circumstances, looking at almost the exact same facts, really, really, really close. And so the judge, instead of spending time hearing Donald Trump deny wrongdoing, just said, no, you did wrong. Let's find out how much money you owe. Offensive collateral estoppel. Pretty cool, right? It makes for the trial to be a lot shorter. It also means that I can confidently predict that Donald Trump will lose because he's already lost. And he's going to have to pay money for sexually attacking a woman in a department store. But, the kind of guy who would do that is presidential material, ain't he? Okay, that was political, not just pure legal. All right, well, let me know what you think about that in the comments down below. Leave me a like, hit that subscription button. I promise when cool legal things come up, I'll jump on here and give my best explanation so that you can be the smart guy at the cocktail party and you can say, why is it that Donald Trump didn't get the chance to defend himself? Well, he did have the chance to defend himself and he already failed. I appreciate you. Thanks.